Well, my talented and respected brothers and sisters, in our continuous journey of self-development, I am excited to present this video before you on the topic of criminal trial, that is prosecution versus defense. This video is beyond amazing. I am covering in this video very important points. Number one, as to criminal complaint. Number two, same transaction. Number three, how evidence on oath can be given. Inbuilt guarantee of truth as to credibility of a witness. Disprove prejudice as of guilt of accused. These are the points to be covered in this video, and this is part 1. Part 2 will be announced next time. Now first, let us start with the root of the problem. It starts with quarrel. Any market starts first with quarrel. Now what quarrel means what? Quarrel means an angry argument, hot argument, a reason for disagreement. Now Latin word is querula. I'll speak the spelling. Q-U-E-R-E-L-L-A. I'll repeat. Q-U-E-R-E-L-L-A. Querula. This is Latin word. It means complaint. From this querula, the word quarrel has come. Now here is the legal point. Quarrel is not a transaction. Hence, it is not an offense in India. Hence, it is not an offense as per Indian Penal Code. Now, I'll discuss about the points. As to criminal complaint. The criminal complaint has to be of the same transaction incident. Our Prosecution citation 2010 in bracket 1 crimes 95 Chhattisgarh. P.S. Chauhan versus Srimati Devikabai and others. What is the important point in this citation? Where criminal complaint alleges different incidents of different deeds which could not be said forming single transaction. Such complaint would not be maintainable. Now in this citation, on perusal of complaint, it was seen that all offences committed were distinct, committed on various occasions and on different dates, defrauded by accused, cannot be regarded as constituting a single series of transactions, as each offence was distinct. Such case would not cover under section 220 of Criminal Procedure Code 1973. Now, just now I said the criminal complaint must be of the same transaction incident. What do you mean by same transaction incident? In order that a series of acts be regarded as the same transaction, they must be connected together in some way. As for instance, by proximity of time, unity of place, unity of community of purpose and or design, and continuity of action. The main test must be continuity of action, by which is meant the following up of some initial act through all the consequences and incidents until the series of acts or group of connected acts come to an end, either by being put an end or abandoned. If any of these things happen, and the whole process is begun over again. It is not the same transaction, but a new one, in spite of the fact that the same general purpose may continue. Restarting of entire process after happening of one act cannot be said to be in the same transaction. It will only be a new one. Now the most important part of the trial, how oral testimony and oath can be given by appearing in witness box before the court. When you go to the court to give the evidence orally on oath, how it can be given. Section 60 of the Evidence Act says oral evidence must be direct. Oral evidence must, in all cases whatever, be direct. That is to say, if it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. Means તમને જે તમારી નજરે દેખાતું હોય એનો પુરાવો રીતે આપવાનો હોય કે મિસ્ટર એ નાયબ મિસ્ટર બી ને આ ચપ્પુથી પેટમાં માર્યું અને મરી ગયો અથવા તો ઘાયલ થયો. This is called direct evidence to the point, and that can be considered by the court. ये તમે આંખોથી જુઓ છો. If it refers to a fact which could be heard, it must be the evidence of a witness who says he heard it. કાનથી સાંભળવાની વાત હોય, કોઈ ધમકી આપ્યો, એ ધમકીના શબ્દો, કોઈ વિભત્સ ગાળો બોલાવે, ગાળાના શબ્દો તમે સાંભળ્યા છે, તો નામદાર કોર્ટ ઓફ વિટનેસ આવીને તમે જે સાંભળ્યું, જે રીતે બોલો એ રીતે એ શબ્દો તમારે કોર્ટમાં પૂરો આપવો જોઈએ. Then it can be considered. If it refers to a fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by that sense or in that manner. આ ગરમ વસ્તુ છે અને તમે ટચ કરો તમને ગરમ લાગ્યું. ઠંડી વસ્તુ છે, બરફ પર હાથ મૂકો તો તમને ઠંડુ લાગ્યું. Means you are experiencing it. If it refers to the opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds. Court calls experts to express opinion. Opinion does not mean to be expert hours in a body color. Means it is proof. No. He has to give reasons. He has to give grounds for his belief. Scientific reasons. Then court will draw the conclusion that this opinion can be considered or not. Provided also that if oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material thing for its inspection. In short, Section 60 of Evidence Act, based on a cardinal rule that the best evidence available must always be given. Section 60 talks about the best evidence. This section aims at the rejection of evidence which is not direct. આ સેક્શન સાંભળેલી વાત રિજેક્ટ કરે છે કે ભાઈ તમે આજે પુરાવા આપ્યો તો કેમ આપ્યો? મેં સાંભળ્યું પેલો આમ બોલતો હતો પેલી આમ બોલતી હતી એટલે હું કહું છું. That is not the evidence. Court will not consider. It should be rejected outright. Court has not seen you at the place of occurrence, that you are the eyewitness. You say that I am eyewitness. God has not seen you there. Judge will not come there. He was not present. How he will appreciate your evidence? How he will trust you that you are the eyewitness? That is the inbuilt guarantee of truth. I will press into solution citation 1991 in bracket 1 GLH 85 State of Gujarat versus Panubhai alias Pariya Kalaji Bhoi. Para number 14.4, page number 93. I'll read out. Thus, before any court can safely accept and rely upon the evidence even of an injured witness, It has got to be closely scrutinized, such evidence by examining it from the following angles. Number one, whether the alleged injury was received in the course of the same transaction incident. Number two, whether the accused was previously known to the witness. Number three, if not, whether the accused was distinctly described in previous statement before police. Fourth, whether there was sufficient light at the time and place. રાત્રે ઝઘડો થયો હોય તો તે જગ્યાએ લાઇટ હતું કે લોકો દેખાય. Whether the injuries were found on the person of the witness rule out a case of self-inflicted injury. There are two parties, A and B. સામસામે ઝઘડો થાય છે. બી પાર્ટીને કોઈ ઇન્જરી થઈ નથી કારણ કે એમણે પહેલાને માર્યા. તો એ શું કરે છે? પુરાવો કરવા માટે બ્લેડથી ઘા પાડશે, ચપ્પાથી ઘા કાઢશે, રવી કાઢશે અને પુલિસને કહે છે મને માર્યો. When he goes to the hospital, doctor will describe the size, measurement, angles. From that it can be decided whether there is self-inflicted injury or not. If it is proved that this is self-inflicted injury, no sentence, no conviction can be accorded to the accused. Any injured witness passing these four tests carries within an inbuilt guarantee of truth, and then in that case, the court can certainly place implicit reliance upon such evidence. Now comes credibility of witness. Whether witness is credible or not, whether his evidence inspires confidence or not, whether it is truthful or not. 1996 Criminal Law Journal 506 Allahabad High Court, Maharaj Dean and another versus the state. Para number 20, page number 7. Important point. A witness who can change his statement as and when it suits him cannot at all be said to be a reliable witness, and such statement has to be discarded outright. In examination chief, સરકારી વકીલ જ્યારે સત્તા પાણીમાં પૂછે એને એક પુરાવો આપ્યો, એ પછી ક્રોસ એક્ઝામિનેશનમાં ડિફેન્સ દ્વારા સવાલ પૂછ્યો તો સત્તા પાણીમાં જવાબ આપ્યો, પુરાવો આપ્યો, એનાથી વિપરીત અલગ ટાઈપનો પુરાવો આપે છે. કોન્ટ્રાડિક્શન્સ, 100% કોન્ટ્રાડિક્શન. એ વખતે કોર્ટ નક્કી કરે કે આ માણસ સાચો નથી, ખોટો છે, 100% ખોટો છે. He is not a truthful witness. So his credibility goes down. Now, when can we say that your complaint is disproved? There is distinction between not true and disproved. Making no allegation is something different, as every fact cannot be known to the prosecution. But making a lot of allegations and inability to prove them gives rise to situation that the prosecution was not coming up with clean hands. It was not a mere case of not proved, but a situation disproved. This has been stated in 1991 Criminal Law Journal 2815, Allahabad High Court. શું કહે છે જજમેન્ટ? તમારી ફરિયાદમાં તમે લોટ ઓફ એલિગેશન્સ કહો છો, આ લખાવાનું, પેલું લખાવાનું, ફિટ કરી નાખવાનું, ચારે બધું ફિટ કરી નાખવાનું. હવે જયારે વિટનેસ બોક્સમાં તમારે આવવાનું છે ત્યારે તમે એના વિશે કોઈ પુરાવા આપી શકતા નથી. ઇટ મીન્સ કોર્ટની શું ફિલિંગ હોય? મીન્સ યુ આર નોટ કમ વિથ ક્લીન હેન્ડ્સ બિફોર ધ કોર્ટ. You are not able to prove any allegations. You are making a lot of allegations without any evidence. So, your complaint is disproved. Hence, accused will walk away with acquittal. Last point in this video, whether prejudice has been caused to the accused. What is the test to be applied for prejudice as of guilt of accused? Here, 1957, Supreme Court 623, Gurbachan Singh vs. State of Punjab, and this citation, here 1956, Supreme Court 116, is relied on by the Honorable Supreme Court. Now, what are the positive findings? Number one, whether the main facts sought to be established against the accused were explained to him fairly and clearly, whether he was given a full and fair chance to defend himself, whether the wrong and defective approach of a judge has caused prejudice to accuse. The court below approached case from only wrong angle, that is, wrong application of legal principles in fact situation. The accused is greatly prejudiced. His liberty is seriously prejudiced, and it is a failure of justice. We can say it is a gross miscarriage of justice. So, Supreme Court insists on fair trial, impartial trial. Things should be decided on merits. Hope all of you have enjoyed this video, and this part 1 is complete. Now in the next part, I'll discuss about defense. I wish all of you to live a life of self-esteem and wisdom. Subscribe it, like it, and share it. If you are new to our video, please subscribe it. Even if you are not new and if you are not subscribed, please do it. And if you subscribe it, then like it and share it. And thank you. We'll meet in the next video.